Vrinda Grover, to you first. Do you believe that this is an order which should lead to some element of accountability? And if so, who is accountable according to you? Because the critical question is, if a fraud has been committed, as the Supreme Court is saying, who is responsible according to you for this fraud? And what happens really to those who allowed the remission to go ahead?
Deep, first just to say, I appeared in the Supreme Court on behalf of the IPS officer Miran Burwankar and other such officers. In terms of who is responsible and accountable, actually the judgment has stated so very clearly and specifically. And it is possible that a convict may come to court and try to suppress certain facts and try to hoodwink the court. And in that petition, in that case, there is the state. The state is present, the state of Gujarat in this particular instance. And the court has said that it was an obligation on the part of the state of Gujarat, therefore, to take the necessary consequent legal steps if where a fraud has been played upon the court. And that step was in the form of a review petition, which the state of Gujarat failed to file. In fact, the court has used very, very clear terms. It's a scathing indictment of the state of Gujarat. And it has said, and I quote from the judgment, instead, the state of Gujarat has acted in tandem and was complicit with the petitioner respondent number 3 herein, had sought before who had come before the court in the initial round where the May 2022 order was passed. So it is the state of Gujarat which is also being held responsible and accountable. Because if rule of law has to prevail, who has the primary obligation? It is the state. And in this case, the court has in fact highlighted that too, that there were facts and circumstances which led to the transfer of the investigation to CBI and trial to Maharashtra. In those circumstances, again, the state of Gujarat is acting in a way which is not with an even hand. It has usurped the power of the state of Maharashtra to grant this en masse remission, which is even otherwise vitiated on many counts. Here, of course, the court said that they had no power, this order that cannot stand, and so it's quashed. But even otherwise, the manner in which it was conducted, if there was a negative opinion, say of the special judge Mumbai, that is overlooked, the fine is not paid. A fine that is directed by a court judgment, the fine is not paid and the remission is granted. It is the state of Gujarat's complete complicity with the mob and the men accused of mass murder and gang rape during the targeted violence of 2002, which is the hate crime against Muslims, which the Supreme Court has underscored again today.
Before I go to my other panelists, let me just get one more clarification from you. The fact is, in May of 2022, the same Supreme Court allowed a committee to be set up by the Gujarat government to review this, to go ahead with the possibility of remission. So was the Supreme Court in the dark at the time? Did the Supreme Court not recognize that Gujarat perhaps was not the only state which had the right to grant remission? Gujarat government said we are going under a 1992 policy of our state. Should the Supreme Court have intervened at that stage itself? 2 years these convicts have been out.
That is precisely what this judgment actually clarifies in details, and it's a point-wise inference, as the Supreme Court judgment calls. It was a different bench of the Supreme Court, of course, before whom one convict, Radhe Shyam, had gone. The same person had actually approached the Gujarat High Court. Gujarat High Court said the appropriate government is the Maharashtra state. Go to Maharashtra. After that order was passed, he moved an application for remission before Maharashtra state. A few negative opinions started coming from the special judge, from the director CBI, etc. At which point, an Article 32 petition, not against, there is no challenge, no appeal against the Gujarat High Court order. A new petition is filed where there is a misrepresentation being made. And it said, oh, Maharashtra High Court says one thing, Gujarat High Court says one thing, I have a right to remission. Who should I go before? who are the two parties before the Supreme Court at that time? Bilkis Bano is not arrayed as a party. The only two parties is this convict who's seeking that he has a right to remission, and there is the state of Gujarat. The state of Gujarat, interestingly, points out that both as per section 432(7) of the CRPC, as well as the Sriharan judgment, which is a constitution bench of 5 judges, the appropriate government has to be the state of Gujarat. The Supreme Court bench passes an order saying, let the state of Gujarat decide. It is an erroneous, wrong order. What is the state required to do? And the state does it very often when it does not actually like a judgment. Here, the judgment is per incurium. It is against a judgment of a larger constitution bench. The state of Gujarat remains conveniently silent and does not file a review. The Gujarat High Court was not informed of the Supreme Court bench was not informed of all the facts. There is a suppression of facts. And that is why the court has said a fraud was played by suppressing facts, misrepresenting facts before the earlier bench. And that's why that order is today a nullity in the eyes of law.
Okay.